Hello guys, how do you feel like this court of observation?
Oh, I find it's quite interesting.
Really? I find there are something really tricky.
Yeah, you are right, Sia. I still remember that the defendant's lawyer actually object to some question raised by DPP, like whether the fridge is in the garage, whether the TV is in the garage, and the judge actually allowed the objection. Why?
Yeah, I think it is because those questions are irrelevant to substance of the case or the cause of action. Basically, I think in the common law system, there are two aspects relating to the determination of relevance. First aspect is whether there is a logical connection between the evidence and a fact in issue. Logical relevance establishes a required base standard before considering legal relevance, which is the second aspect. The test for logical relevance is defined in Section 55 of UEA. However, the definition is not comprehensive. In determining relevance, it is quite important to identify what are the issues in the trial. The focus is on whether the evidence is capable of affecting the assessment of the probability of a fact in issue. I remember in the case name is Goldsmith, and the court held that facts are relevant if they constitute the claimant's cause of action and the facts to which the law attach the legal consequence that the claimant asserts. In the present case, I think the DPP asked what the fridge in the garage was the TV in the garage. I feel like the trial judge allowed the objection by the defense because they are not relevant either to the cause of action or the legal consequence. Section 56 of UEA provides that evidence that is relevant to the proceeding is admissible. On the other hand, evidence which is not relevant in the proceedings is not admissible. Under the common law, not all logically relevant evidence is admissible. It must also be legally relevant. Under Section 135 and 137, the court has wide discretion referring to the admissibility of evidence. Both sections require a trial judge to compare the probative value with prejudicial effect. In Burton, the court affirmed that evidence should be excluded if its significant probative value outweighed by any prejudicial effect of it. Section 137 only applies to evidence provided by the prosecution rather than the defense evidence. In a criminal proceeding, the court must refuse to admit evidence adduced by the prosecutor if its probative value is outweighed by the danger of unfair prejudice to the defendant. In Burton, the danger of unfair prejudice outweighed the probative value because the interpretation favorable to the party is not admitted who tendered the evidence, and the trial judge accepted the alternative one. However, evidence is not unfairly prejudicial merely because it is more likely that the defendant will be convicted. In R and XY, in determining the admissibility under Section 137, the judge should assess the capacity of the evidence and whether all favorable inference can be drawn upon. In the present case, the evidence is logically irrelevant and thereby excluded. There is no need to further consider the admissibility under Section 137 and 135. By the way, do you know why the four witnesses were in front of her owner in different formats?
Well, when we talk about the sworn evidence, we know it could be given under oath or by affirmation. The witness in a proceeding must take one of them before giving the evidence, unless he or she is making unsworn evidence under Section 13 or merely produce a document or something like that. Witnesses are aware that they are obligated to tell the truth in the courtroom, or they will be liable to some kind of punishment if they don't.
But I'm confused because you know that one of the witnesses is the accused brother.
Okay.
How about if he unwilling to testify, can the court compare it to do so?
Yes, in the common law we know that any competent witness is comparable, and however it has been recognized that the family relationship could be destroyed, like comparing the witness to testify in the courtroom. According to the Section 18 of the Evidence Act, the current statute only applies to the spouse, the de facto parent or child of the defendant. So the brother in this case should not be covered in the statute. So, and there's no, as far as I can remember, there's nothing to question his competence. So I think he would not be able to object to being compelled to go into the courtroom.
Do you remember that during the examination, the first witness used some documents to refresh memory? Is that okay?
I do remember. At common law, a witness may only rely their evidence by the document with the permission of the court in a voir dire. And according to Section 32, the court must give leave before witness can use a document to refresh their memory. And the granting of leave requires consideration of matter is in Section 192 and 2 factor, which is they had to exalt their memory, and the document was made by the witness when the memory was still fresh. Here the court must have previously considered the both factor and then grant a leave for the witness to do so. Thanks, Fia. Hey, you still remember that? The defense lawyer actually don't really familiar with all the scientific evidence, and I can't believe that the prosecutor is so nice. He actually asked the court for a break, and so that the defense lawyer had enough time to get familiar with all the scientific evidence. Prosecutor, so friendly to the defense lawyer. What do you think?
Yeah, I think it is interesting to see such a friendly proceeding, which is supposed to be, compatible with accusatorial system. But actually, apart from that rival characteristics, actually the prosecutor is also under a duty to assist the court to arrive at truth. Yeah. So, and also under Section 147, this kind of disclosure obligation is ongoing, which means that the prosecutor shall disclose any relevant information even after the pre-trial assessment.
Do you still remember that the defense lawyer actually asked the witness whether he had any knowledge about the transaction? Mm-hmm. And neither the judge and the DPP had any objection to this question. I was very confused. I think it's not this particular court proceeding not satisfied with the credibility rule.
I think you should have read Section 102 and 101A together. Because Section 101A is a two-stage structure. Subsection A states that only when the evidence is solely relevant to credibility, then the evidence can be regarded as credibility evidence. In the present case, the question is not merely relevant to the credibility of the witness. It is also relevant to other issues such as the motives of the perpetrator. So that could be more relevant to subsection B of 101A. The Adam and the Queen control was removed by Section 101A, Section B, and the rule now is that if the evidence affects the assessment of the credibility and for other purpose, the evidence could still be regarded as credibility evidence. The leading question is Goldsmith, which opens a gate for the collateral evidence being regarded as credibility evidence. In present case, I feel the question is not only relevant to the issues such as the motives of the perpetrator, but to the credibility of the evidence. Therefore, potential incompliance could have arisen. However, I would like to draw your attention to Section 103, which is the exception to the credibility rule in cross-examination. Under 103, credibility rule does not apply in cross-examination if the evidence could substantially affect the assessment of the credibility of the witness. Given the close relationship between the witness and the disease, and the diseased past drug dealings, there is possibility that the witness knowingly or recklessly made a false representation so as to hide his potential crimes, which is quite similar to the case R and Lodi. By further considering the long elapsed time since the crime committed in 2001, the present case satisfies Section 103. Therefore, the credibility does not apply. Since the present case falls within the exception as per 103, I think the court procedure complies with the credibility evidence principle under UEA.
Thanks for watching.
Daniel, give us a good mark!